to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning, everyone. Housekeeping announcements first. The First District Court of Appeals graciously lets us use their facility, so please respect their rules and have absolutely no food or beverage other than water in this room, and please silence your cell phones. Anyone addressing the commission, please speak up so our recording equipment can pick you up properly. And to my fellow commission members, please speak up and into the microphone so you can be heard. Members, I ask you to be as brief as concise as possible in your questions and comments, as we have a number of items for consideration today. Pursuant to Section 286.0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means that the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard on a matter, please fill out the speaker card and give it to Ms. Fulford, who has her hand up. All right, first item on the agenda is approval of the minutes from the public session meeting on September 8th, 2023. These materials were in the packet that we received. Is there a motion to approve the minutes?
Move approval.
Second.
All in favor?
Aye.
The minutes are approved. Okay, so we're going to take something out of order on the agenda. I wanted to start with item 10, the selection of the vice chair. First this morning, before we get into the substantive issues, due to the resignation of Vice Chair Gates, we need to select a new vice chair. The vice chair will serve in that capacity until September 2024, and at that meeting, the commission will select a new chair and vice chair. Are there any nominations for vice chair?
Madam Chair, I would nominate Commissioner Ankers.
Dang, I was just about to nominate Commissioner Cervone. You should vote against both of us.
I'll second that.
Okay. Are there any other nominations? All right. All in favor?
Aye.
Aye.
All right. Congratulations, Commissioner Ankers, new vice chair. Congratulations.
Happy face.
If they let me drink coffee here, I'd be quicker.
All right. And now we'll move on back to the regularly scheduled programming. The first item, or the next item, item 4, is consideration of final action on a pre-probable cause stipulation. This is in re Leslie C. Riccardelli, and I apologize if I butchered that name, case number 23-108. Will the parties or their counsel please identify themselves for the record?
Mark Aaron on behalf of
Melody Hadley, Commission Advocate.
Okay, we have before us a proposed pre-probable cause stipulation between the commission advocate and the respondent. This matter is being considered in the public session meeting because the respondent, in signing and filing a pre-probable cause stipulation, waived confidentiality. Complainants have the right to comment in writing on proposed stipulations, and we have not received any comment from the complainant in this case. After considering all the materials in the presentation of the parties, the commission may vote to approve or reject the stipulation. As this is a pre-probable cause stipulation, if it's rejected, we'll go immediately into the probable cause determination. Are there any members who need to make a disclosure in this matter? All right, Ms. Hadley.
At this time, I bring before you a pre-probable cause stipulation. Respondent acknowledged that she failed to accurately file a 2021 CE Form 1 in violation of Section 112.3145. Respondent filed a CE Form 1X amendment to Statement of Financial Interest for that year. We asked the Commission to accept the respondent's stipulation that she violated the aforementioned statute and recommend a total civil penalty of $1,000. Thank you.
Any questions from the members for Ms. Hadley? No? Mr. Herron?
Madam Chair, Mark Herron on behalf of Ms. Riccardelli. If you read the report of investigation, you will see that this is a classic example of why not to fill out your financial disclosure form on the last day and in haste. And as a result, Ms. Riccardelli made a few errors, okay? She forgot to check the box, what kind of method she was using for reporting her financial interests. She overlooked the fact that she had a lease car, and the lease car has to be reported as an asset and a liability. She overlooked that. And she didn't realize that, or didn't know at the time, that there was this fine that was imposed on her husband's business with respect, that was a liability that she, not a business, but it was a fine that was imposed that she had was liable for, as well as her husband. So with those facts in mind, we negotiated a settlement, and I would urge you on behalf of Ms. Riccardelli to accept it and approve the joint stipulation. Thank you.
Any
I have a
questions?
question, Madam Chair.
Sure.
Is the defendant, is she a newly elected individual, or is it the first time doing a Form 6, or could you respond upon that?
She had previously filed, these are Form 1s, they're not Form 6s.
I'm sorry. Form
She had
1.
previously filed them when she was in a position previously with the Collier County School District. There was a number of years subsequent to the last one she filed, which I think might have been 2016, but I'd have to look at the report, before she became now the superintendent, the appointed superintendent of the Collier County School District. So again, she had previously filed them, had not done them for a while, and this was the first opportunity she had filed with respect to her new position as the appointed superintendent.
Through the chair. This is the first one as the superintendent, you're saying?
Yes, I believe so. I don't know what position she had previously, but I don't believe it was superintendent.
Thank you, Madam Chair.
Are there any other questions? Is there a motion to adopt the stipulation?
So moved.
Second.
All right, all in favor?
Aye.
All right. Thank you all. All right, next up is consideration of final action on another stipulation, item 5, and Ray William Oppenheimer, case number 22-163. Will the parties or their counsel please identify themselves?
Good morning, Commissioners. I'm Elizabeth Miller, advocate for the Commission. The respondent was a write-in candidate for the Collier County Commission in 2022. He filed a 2021 CE Form 6, which is a full and public disclosure of financial interests, as he was required to do by law. He made mistakes on that form, and there's one allegation. He has subsequently corrected the form. In the probable cause before you, he admits that he made mistakes. As I said, he amended his form. He's agreed to pay a $1,500 fine as a civil penalty, and we ask that you approve and adopt the probable cause stipulation. Thank you.
So before we get ahead, I just want to check and see if there's anyone who needs to make a disclosure on this one.
Move the applicant's recommendation.
I have a question.
Please.
I have a question regarding the agreed-to fine. On the prior case, it was $1,000. On the subsequent case, it's $1,000, and this one's $1,500. And to me, of the three, there were mitigating circumstances here with having had a stroke and withdrawal and all kinds of issues. I was just wondering why we're levying the higher fine in this case and not the other two.
That's just what he agreed to pay. That's what we stipulated to.
Yeah.
And to clarify, it's only an up or down vote at this point, right?
Yeah.
Okay.
Can we modify it here on this? No?
Not at
We
this
just
stage.
have
We
to
would have to
accept it
reject
as
it.
it is?
This is a settlement agreement,
Yeah,
so
I
the commission
understand
can't
that.
negotiate, and so it's an up or down vote. If you all adopt it, the case is done. If you reject the stipulation, they would go back to negotiate a new stipulation, or they would go to hearing.
Are there any other questions?
Just because I'm new, is there a scale, a standard where you start? And I mean, I think it's a good question of why it's different. Is there a
Through the chair, it's very fact-intensive. These cases are all different, even though they failed to file or they made mistakes. It depends on the number of mistakes, so on and so forth, but we're in the general range of $500 to $2,500
So did
is
he
what
make-
we've been asking.
Did he make more mistakes compared to the one before and one after? Is that,
He did make a lot of mistakes on this one, and then he attempted to amend it. He didn't file it on the correct form, which would have been a 6X form. So that played into it also.
when he attempted to amend it, was that after his stroke? And did the 6X, that's the amendment?
Yes, it was after he
So
had a stroke.
after
Yes,
he
ma'am.
had a stroke. Okay.
Pre-probable cause, both, pre-probable.
Oh, and what Ms. Hadley's was a pre-probable cause. So there was a step, it was a step before there was a probable cause hearing, if I may, through the chair, I'm sorry. And that was one of the reasons why the fine would be lower, because it was done very quickly, resolved very quickly.
Thank you.
All right, there's a motion to adopt the joint stipulation. Is there a second?
Second.
Okay, all in favor?
Aye.
All right. Thank you. Okay, now on to 5B, In re Heather Post 22-164. We have another proposed joint stipulation between the commission advocate and the respondent. Prior to the stipulation being filed, there was a motion to dismiss filed by the advocate and then a motion to withdraw the motion to dismiss. So we'll start with the motion to withdraw, but are there any members that need to make a disclosure first? And could the parties or their counsel identify themselves as well?
Mark Herron on behalf of Heather Post.
Thank you.
Elizabeth Miller, advocate for the commission.
So let's start then with the motion to withdraw.
Yes, we just request that you allow the motion to withdraw be granted. We do have a stipulation.
So I have a question on this one, and it's procedural. The motion to dismiss was jurisdictional, is that right?
Through the chair, obviously. Yes, ma'am, it was.
Okay, so if,
But it was an incorrect analysis, I'm sorry.
okay. Could you explain that a little bit, why it was an incorrect analysis? Just, I want to make sure that if we're going to move forward, we have jurisdiction.
Yes, if I may. The particular person in this case, the respondent, she is no longer in position. And if it is a willful case where someone willfully fails to file their Form 1 or Form 6, the only potential penalty is removal from office. However, if the respondent leaves office afterwards, then it's the commission's position that they no longer have jurisdiction. The ultimate penalty has been paid by leaving office, whether voluntarily or not, so there is no penalty that can be imposed. Therefore, you don't have jurisdiction anymore.
But that's not the way we are.
I beg your pardon, that is not this case. That is not, I misconstrued this case. That is not what happened in this case.
So Ms. Post is still,
So Post is still a valid case, you still have jurisdiction.
she's still in a position.
She's no longer in her position, no. But this was a complaint. A complaint was filed rather than self-initiated by the commission.
Okay, so that's the difference.
That's the difference.
Okay, and just because I lost you, go ahead.
If I may assist for your comprehension
Please.
here. There's two types of cases that we typically do with these financial disclosure
Okay.
situations. Most typically, what we would see is a case that's initiated by a complaint from a member of the public. In this case, I think the allegation was something along the lines of this respondent failed to file timely, which is a requirement of the law. A complaint was filed, we investigated it, and here we are. Separately, sometimes you'll see cases where somebody has accrued the maximum fine and the commission must, without any discretion, must self-initiate an investigation to determine whether or not the failure to file was willful. And in those instances, the only penalty is removal from office. The motion to dismiss looks like it was arguing that we didn't have jurisdiction to perform a willful case, but it wasn't a willful case to begin with. It was a complaint initiated by a member of the public. So we retain jurisdiction even though the person has left their position. And so that's why the advocate filed the motion to withdraw the motion to dismiss.
Understood. Thank you all very much. Are there any other questions before we consider the motion to withdraw? Okay. Is there a motion to grant? request?
No,
Move
she didn't.
approval.
Okay, second.
Second.
I thought the advocate was gonna give her a spiel. I didn't.
Well, she did on the motion to withdraw, right? Okay. All in favor?
Aye.
Okay.
Now we're back on the schedule.
All right, so now we're back on the schedule. All right. So we'll consider the stipulation now, having granted the motion to withdraw, the motion to dismiss. So we can approve or reject the stipulation, and if it's rejected, we can't renegotiate the new stipulation here. It would have to go, the complaint would go to the Division of Administrative Hearings for an evidentiary hearing, or the parties could negotiate a new settlement for consideration at another meeting. The complainants have a right to respond in writing to the proposed stipulations. We've not received any comments from the complainant in this case. Ms. Miller, you can go ahead and present the stipulation.
Thank you. The respondent is a former Volusia County Council member. As such, she was required to file a timely CE Form 6, which again is a full and public disclosure of financial interests, and she failed to do so in 2021. However, she did eventually file it, and she paid the $1,500 maximum penalty that was imposed by law. The respondent admits the allegation in the joint stipulation, and she's agreed to pay a $1,000 civil penalty. We ask that you approve and adopt the joint stipulation. Would like to point out that the total fine for her would be $2,500 in this case, because she paid the statutory penalty also. Thank you.
Any questions? Mr. Herron?
Madam Chair, members of the commission, Mark Herron on behalf of Heather Post. The materials you have in front of you, I just want to add one fact to that, and it can be verified by everybody here in the works for the commission. It says that she had not filed her 2021 financial disclosure, if you look at the report of investigation. She did file that financial, that 2021 Form 6. I have a copy of it right here that I pulled down from y'all's website this morning. And it was filed in February 8th of 2023, and that's going to become important when I tell you why the fine in this case is $1,000. Ms. Post wrote a letter to the advocate, Ms. Miller, back on March 22nd, 2023, that explained to Ms. Miller why she had not filed timely her Form 6. The facts and circumstances kind of relate to two things. One, she had a number of health issues that developed when she fell down the stairs in April of 2022, and injuring almost, as she says, a number of bones in her body, most of all of them, but she was homebound, recuperating from that fall from April 2022 through essentially July of 2022. In July of 2022, she attempted to go back. Again, this record, I don't think this letter is in your file, to tell you the truth. But again, I have a copy of it. It was an email sent to Ms. Miller. And Ms. Miller called me when she got the letter and said, hey, why is your client sending me this letter? Sometimes we have clients that reach out directly and go around the lawyers. But anyway, she wrote this letter. And so in July of 2022, she tried to go back to work as a county commissioner in Volusia County. At that point in time, she felt threatened by an individual who was showing up at county commission meetings and in the county offices, threatening her and threatening other county employees. As a result, she never went back to another county commission meeting in person, okay? Subsequent to that, in September, another individual was threatening her, and again, as a result of that, she basically stayed at home and homebound. Now, in her letter to the advocate, she says, and I'm going to quote, "In September, she discovered that her financial form had not been received by the state. I called them and said I would mail it out. I completed the financial form, had it notarized by my assistant, and prepared it for mailing. She later discovered in February of 2023 that that had not been mailed." Back to this form that was filed with the commission. This form was received by the commission in February of 2023, but when you get to the notary page, the notary part of the form, which verifies her statements, it is notarized by her assistant on September 6th of 2022. So she fully intended to file it in September of 2022, a few days late, but again, those are part of the mitigating circumstances which we believe in our discussions justify the penalty of $1,000 in this case. And I'm happy to answer any questions.
Are there any questions? Is there a motion to approve the stipulation?
So moved.
Second.
All right, all in favor?
Aye.
Thank you very much,
Thank you.
appreciate it.
Okay. All right, next is consideration of motion to dismiss in re Steve Kenny, case 19-196. Will the parties and their counsel please identify themselves?
Elizabeth Miller, advocate for the commission.
This is a case arising from the requirement that the commission self-initiate complaints against persons who currently hold public office or employment and fail to file a disclosure and receive a $1,500 automatic fine. The purpose of the investigation is to determine whether the failure to file was willful, and the only available penalty is removal. This matter has been investigated, and a motion to dismiss for lack of jurisdiction has been filed by the advocate. Are there any members who need to make a disclosure? Okay, Ms. Miller, you're recognized.
Thank you. Commissioners, this is one of the cases you were just told was self-initiated by the Commission on Ethics. So in 2017, the respondent was serving as a member of the Tampa Employee Retirement Board, and he failed to timely file his 2017 CE Form 1, which is a statement of financial interest. His term expired, and then the commission lost jurisdiction. For that reason, I'm asking that this case be dismissed for lack of jurisdiction. Thank you very much.
Move approval of advocate's recommendation.
Second.
All in favor?
Aye.
Thank you.
All righty. Moving on to item 7 is the consideration of an advisory opinion, file 2803. Any public officer, candidate for public office, or public employee in Florida who's in doubt about the applicability of the disclosure laws or standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Is the requester here?
The requester is not here, Madam Chair, but someone from his firm is. This is Tim Elliott.
Good morning. Okay, and are there any members who need to make a disclosure? Mr. Schaefer?
Thank you, Chair. This advisory opinion is coming from a Brevard County Commissioner who's employed by a law firm, although he is not an attorney, which is an important thing to keep in mind. At the firm, he's their Director of Government Relations, which means that he engages in lobbying on behalf of different clients that contract to have the firm conduct lobbying for it. And he's wondering if he can lobby on behalf of the cities of Satellite Beach, India Atlantic, and Cape Canaveral, which are 3 cities all within Brevard County, so long as he keeps his lobbying efforts to government entities other than Brevard County where he's serving as a commissioner. In particular, he'd like to lobby through the firm and on behalf of these cities, the federal government, the state legislature, and other state and local agencies and political subdivisions, again, other than Brevard County. Now, that question seems pretty straightforward. The opinion is rather lengthy, though, for reasons I'm about to go into. But as I work through it, please keep in mind this morning that it's important you confine your analysis just to the ethics laws that exist today, not to the laws that may have been in place several months ago or to laws that may come to pass in the future. And as you can see in the draft, my recommendation is that under the currently existing ethics laws, and subject to the cautions in the draft, his lobbying on behalf of these cities, of entities other than Brevard County, does not appear to create a prohibited conflict of interest for him. Now, the reason that timing is important is that until recently, there is a constitutional prohibition on certain kinds of public officers, including county commissioners, lobbying for compensation during their term of office before the federal government and state and local agencies. This is part of that recent constitutional amendment about ethics that was passed by the voters back in 2018. And this county commissioner, I will say, appears to have tried to comply with that prohibition. He was appointed by the governor to his seat on the county commission in June of this past summer, June of 2023, and immediately he stepped back from conducting any lobbying, given his position on the county commission made him subject to this in-office lobbying prohibition. But the constitutional lobbying ban was the subject of a court challenge, as I'm sure some of you know. And this past August, which was a few months after he took office, a federal court issued an injunction against enforcing it, essentially declaring it to be unconstitutional. Now, that injunction is being appealed, and a motion to stay the injunction during the pendency of the appeal has been filed, but as far as I'm aware, that motion has not been ruled on yet. So as it stands today, the Ethics Commission has no authority to enforce that constitutional in-office lobbying ban, meaning it's currently off the table unless the courts tell us otherwise. So in light of that, this commissioner is inquiring if there's any other ethics laws that prohibit him from lobbying during his term of office on behalf of these cities, again, as long as he keeps his lobbying to entities other than Brevard County. This question is not new. The Ethics Commission has written opinions on this before about whether a public officer can engage in lobbying during a term of office. The statute in question here is section 112.313, subsection 7A. That's a law that deals with having outside employment or contracts that could create prohibited conflicts of interest for you if you're a public officer. Now that statute, 112.313 subsection 7A, has two parts. I'm going to work through them both this morning. The first part is very mechanical. It sets out some very simple elements, and if you're a public officer and you meet them, if you check off all those boxes, you'll be held in violation. There's not a lot of wiggle room. It says a public officer, like a county commissioner, can't have an employment or some type of private contract with a business entity or an agency if that business or agency is either conducting business with his board or is being regulated by his board. Now, as the draft explains, if this lobbying goes through and this commissioner starts lobbying for these cities, his law firm will be entering into lobbying contracts with the different cities. But those contracts will just be with the law firm, not with him personally. So technically speaking, and the first part of the statute is very technical, his employment and contracts will be just with his law firm, and we have no indication that that law firm has any business-related or regulatory interface with the Brevard County, even if some of its clients, like these cities, might. So again, mechanically speaking, this scenario doesn't meet the elements of the first part of the statute. Even if he conducts this lobbying, he won't be employed by or have a contract with any business or agency that's interfacing with Brevard County. Now, the draft does go into detail about how the Ethics Commission in the past has found that attorneys at a firm do have a contractual relationship with each of the firm's clients. So if those clients have business or regulatory dealings with an officer's board or agency, that could create some questions. But imputing that contract with a client from the firm to the attorneys at the firm, that's a concept that comes out of the Florida bar rules. That's just applicable to attorneys. Like I said at the beginning, this county commissioner is not a lawyer. He's not subject to the bar rules. So it can't be said then that he'll have any contractual ties, any contractual privity with these clients, even if they contract with his law firm to conduct lobbying on their behalf. So again, I don't believe the first part of the statute will apply here because technically speaking, even if this lobbying occurs, he'll have no employment or contract with any entity that's interfacing with Brevard County directly. Now that's the first part of the law. What about the second part? The second part of section 112.313 subsection 7A is more situational. It says if you have an employment or a contract that could even tempt you to compromise your public duties, no matter who it's with, that can create a prohibited conflict of interest for you. It literally says if you're a public officer, you shouldn't have an employment or contractual relationship, and this is a quote, that could impede the full and faithful discharge of your public duties. Now, in the past, before this constitutional amendment was written in 2018, the Commission on Ethics analyzed these same kinds of lobbying questions about public officers who wanted to engage in lobbying during a term of office. It looked at it under the second part of the statute, and it came up with a couple of guiding principles. It said, first, you shouldn't lobby your own agency or board on behalf of a paying client, which is a problem for clear reasons. You shouldn't jump off the dais and then come down to the podium in the middle of a meeting and start arguing a matter to your own board. Now, getting past that, the second thing the Commission has found is that as long, though, as you confine your lobbying to government agencies other than your own, the mere fact that you might be engaged in lobbying on behalf of a client won't trigger the second part of the statute. There's several opinions in the draft that cite that going back to the 1970s, so that's something the Commission has long held. And really, that's why the constitutional amendment in this regard broke new ground several years ago, because until that point, there was no other law that flatly prohibited a public officer from engaging in lobbying during a term of office, again, as long as they weren't lobbying their own board. Now, that's just for the general question of whether this commissioner can engage in lobbying on behalf of these cities. That seems okay, as long as he's not lobbying Brevard County. The situation becomes a little bit trickier, I will say, because we've been told these cities he's hoping to lobby for occasionally do have matters coming before Brevard County Commission. The matters concern interlocal agreements that the cities have with the county. So we've got to address that as well. Does that create a problem under the second part of the statute? When these lobbying clients may from time to time, separate and apart from his lobbying efforts, have issues that they might be presenting to his board, the county commission. Well, from what the Ethics Commission has found in the past, the fact that you're employed by a business or have a client that may from time to time lobby your own board, that as well is not an automatic conflict under the second part of the statute, as long as you totally divorce yourself from having any responsibilities regarding your employer or client's lobbying of your board. So you can't help them in any way. The draft cites 4 prior ethics opinions, each finding no conflict of interest for this type of behavior, although they do warn the public officers involved that their employment should be completely separate from any lobbying that their client or their employer does before their own agency. I would encourage the Commission to follow those prior opinions here. So essentially, kind of draw this all together under the second part of the statute. It seems that he can't lobby Brevard County, which he said he's not going to do. He needs to make sure that he confines his lobbying to other government agencies, which he says he will do, and he can't assist these cities in any way in presenting matters about these interlocal agreements to the county. But as long as he complies with that, given our past opinions, it doesn't seem that he'll have a prohibited conflict under the second part of the statute. So basically, this is just resetting everything to how things existed before that amendment was written. I know my comments here have been lengthy. It is a long opinion. I just have a few more points that I do want to make as I close. Critical to this analysis is that he's not an attorney. If he was, then under the bar rules, he'd have a contract with each of his firm's clients. The courts say that creates a duty of loyalty, and we'd have to tackle some other issues that we frankly don't need to get into here this morning because he's not a lawyer. Also, we're being told that matters involving these cities and their interlocal agreements with the county only rarely come before the county commission. So it doesn't seem he's going to have much to do with these cities in his capacity as a county commissioner. And you can couple that with the fact that the law firm, we've been told, pays him a set salary as just a run-of-the-mill employee that does not fluctuate. Meaning that even when issues about these cities might occasionally come before the county commission, he's going to have less incentive to decide matters in their favor because his salary at the law firm is going to stay the same regardless of how it comes out. And the opinion also points out under the voting conflict law that he won't have any voting conflicts about these municipal clients because agencies like cities are exempt from the reach of the voting conflict law. Now, all that being said, the draft does make clear that he should not be attempting to use his position in any improper way to benefit these cities if he starts lobbying for them. That means he can't be using his position as a county commissioner to set up meetings where he can kind of advance their interests. It means not using his position to obtain and then pass along to them confidential information that might come his way as a county commissioner. We can't presume that's going to happen, but the draft does warn him he could be the subject of an ethics complaint if that does occur. Thank you for your attention. I know these comments have been lengthy, but I hope they were clear. Mr. Elliott is here as well. I've been told by him that the requester agrees with the opinion and is comfortable with it. I offer it now for your review, and I'm happy to answer your questions.
Thank you. Are there questions? Go ahead.
Thank you. You spoke to interlocal agreements, but what about sole source providers?
I'm sorry, Commissioner?
What about sole source providers?
Sole source providers. Well, that's a question the draft really didn't have to tackle. The draft is tailored just to the individual facts presented, which are just about cities that may have interlocal agreements with the county.
Through the chair. What I was getting at was a lot of, they have interlocal agreements, but they also have only one entity that can provide these services to these municipalities, thus making it a sole source provider. So I asked, you didn't speak to that. You spoke to interlocal agreements, but if it's an interlocal agreement with a sole source provider that she's helping, then how do you get around that?
I see what you're saying. I think that to tackle sole source and the different exceptions to the first part of 112.313 subsection 7A is going to get into some complexity that the facts don't really need to get into here. The reason is he doesn't have, like I explained, a contract personally. He's not in contractual privity with any of these cities. Now, if he was in contractual privity with them, if they were directly contracting and hiring him to lobby, then he would have a contract with an agency interfacing with Brevard County. That creates some concerns then under the first part of section 112.313 subsection 7A, which, like I said, says you can't have a contract with an agency doing business with your own board. Now, if that was the case, then we would look to see if any exceptions to the first part of the statute were to apply. One of those exceptions, like you said, is if the person you're contracting with is the sole source of something that your agency needs. Another potential exception that pertains to interlocal agreements, intergovernmental agreements, is when they're just for the provision of services. The Commission has found that when two agencies are working together to mutually provide services to the community, it's not going to consider that to be doing business, and so it doesn't trigger the first part of the statute. So I see where you're going, but frankly, we don't need to even look at the exceptions to the first part of section 112.313 subsection 7A, because they would just be applicable if he was in contractual privity with these cities, and it does not appear that that's the case. He just has a contract with his law firm.
Through the chair. Through the chair.
Sure, and then.
You spoke about him not being able to use his status as an elected official or whatever. Most of these lobby firms hire you because of your pedigree and your access and people that you know. How does that work when you go in to get meetings and you're just Joe Public instead of Representative Newton?
That's why the commissioner, the opinion makes very clear, Commissioner, that he can't be using his position in any way to further the interests of his client. And I think, I forget which page it is on, but the draft warns him at the end of question 1 that it could be a potential misuse of his position. He could trigger some concerns under the disproportionate benefit amendment in the state constitution if he's using his position just to set up meetings where he can advocate for his client. Or I suppose, too, if he sets up meetings under the guise of county business and gets into the meeting and suddenly says, what I really want to talk to you about is these cities and their needs before you. That could raise some concerns under these two provisions. But, the question in general, while we do warn him about that, is this an automatic conflict? And I think the Commission has been very clear in the past that it's not. And so what I'm recommending this morning is that we just rewind the clock back to how things existed before 2018 when that amendment was written, which kind of changed the field in terms of this. I think there's solid precedent out there and Commission opinions for finding this is not a conflict.
If I may just jump in for a moment. The question that you're asking, hey, what's the difference between using your position affirmatively to get these meetings and just the fact that your aura, you are who you are all the time, you're a public officer all the time when you walk into these meetings. And that was the beauty of what the constitutional amendment was. It was a total ban on lobbying while you're in office, and it didn't require an affirmative use of your position to get to that ban. The misuse provision, which is what Ray is talking about, requires an affirmative use of the position. That's the statute that's in play right now. The in-office ban is currently inoperable and under appeal. that decision's under appeal. So those are the differences between the two. So you're right to have that concern. It was addressed by the former law. It's not currently in play now.
Commissioner Trowbridge, did you have a question?
I had a question. So is he in office now or no longer in office?
He is currently in office.
Okay. And he works for the law firm. So would that be classified as Company A going to do business with Company B? And was the law firm already doing business with the city before?
Well, as you can read in the draft, once he was appointed in June, I believe that those cities contracted, or at least the work was subcontracted to another consultant to conduct lobbying for them. I think one of the cities dropped the law firm completely from doing lobbying. So right now he's just wondering if, hey, can I go approach these cities again about conducting lobbying on their behalf?
Yeah, to Steve's point about being a commissioner, he's a commissioner 24/7 under the law. You're hinging part of this opinion on that the individual is not a lawyer.
Yes, sir.
Okay. We're in a town full of law firms that hire people, whether they're a lawyer or not, but they're not members of the firm. They're contracted as well to the firm. So if this individual was a lawyer, I'm thinking about potential future opinions that are going to be asked because of this. If the person wasn't a lawyer but contracted to the firm to provide specific services, not a member of the firm, under a contract, would this same scenario apply as well if they were a lawyer, or would being a lawyer be 24/7 no matter what under this opinion?
I think I understand your question. Let me see if I can give you an answer, and then you let me know if I'm not meeting your concern. If someone I think if it's an outside consultant that a law firm just hires for a certain period of time who's not an attorney, I don't necessarily see any difference in terms of this. You know, the contract would still just be with the law firm, not with the individual clients. I don't see it changing the analysis under either part of the statute. If the individual was an attorney, whether an attorney at the firm or some outside counsel that the firm contracts with, it does get a little bit trickier. I want to emphasize we don't need to tackle that this morning. This opinion in no way really affects the analysis if someone is an attorney. This individual is not. Just for the sake of argument, though, if someone is an attorney at the firm, the bar rules say that you then are in contractual privity with each of your firm's clients, even if you aren't necessarily performing services on their behalf. The courts have also been very clear. I just read yesterday a Supreme Court case just from a few years ago that said if you are an attorney in contractual privity with a client, you owe them a high fiduciary duty of loyalty. The courts have found that to be one of the most confidential and sacred duties that a person can have. So, essentially, attorneys are treated a little bit differently than run-of-the-mill employees of a law firm. If you have a client at the firm then that has matters coming before your board or your agency, that would require a whole separate analysis. Critical to it, in part, would be is the firm actually presenting these matters before the board that you're serving on. I do know there's an advisory opinion that I cite in the draft, 12-21. I think it dealt with a county commissioner who was employed by a law firm, very similar to here, except he was an attorney. Some clients at that law firm were cities that had interlocal agreements with the county. Now, under that very narrow circumstance, I believe the commission analyzed the question of the first part of the statute, like I talked about in response to Commissioner Newton's question, and it found that the only doing business component were interlocal agreements for the provision of services, so it didn't trigger the first part of the statute. Under the second part of the statute, under those very narrow facts, it found, yes, this individual is an attorney. Yes, his law firm does have clients presenting matters before the county commission where he's serving. But the opinion went on to say this law firm is not presenting those matters, and it recognized a little bit of a distinction because it said, look, these matters are only infrequently presented, and given the fact that we're dealing here with clients who are public agencies, cities, and the county doesn't have any regulatory authority over cities, the commission found in that opinion that there was no conflict either under the second part of the statute. You know, but I guess to kind of boil down your question, if the individual is an attorney, there is contractual privity then with each client at the firm. there is a duty of loyalty owed to them. That would require more complex analysis under this particular statute, but again, we don't need to get into that today because this individual is not an attorney.
Thank you.
A comment more than
We'll go down
question.
the line. Please, no, go ahead.
Really, my comment is this strikes me as very nuanced. It also strikes me as putting this individual in a perilous position. He obviously knew that there was some peril, or he wouldn't have come forward to ask the question to begin with. I don't think that we can anticipate every conceivable eventuality that might come up in an opinion of this sort, and I think this opinion does a pretty good job of warning him that he is at peril if he deviates from any of the things you've advised him need to be considered. I'm supportive of the opinion.
Thank you. And through the chair, I echo that. I found the opinion to be extremely well-written, very nuanced, very, I call it a near miss. It reminds me of days of playing Battleship. You got like a near miss, like you know it's close, but it's not quite there. And with respect to the comment that you put on there, it's on page 15, by the way, about the fact that he's got to be careful about the constitutional issues. And that seems to be more fact-specific than automatic, which is very, very gray in the sense of, as my fellow commissioner says, you got to be very careful about the action you take while you're doing this job, because it could lead to the door being not slightly open, but wide open. But I agree with the opinion.
Please.
Sorry, just keep going. You said it was gray. The author's name is gray. His suit's gray. On page 7 of the draft opinion and throughout, there's an indication, of course, that this individual, the Director of Government Affairs, does not have a contractual relationship with the clients. His contractual relationship is only with the firm itself. If you changed the word, as the statute does, give an alternative to employment or contractual, and said that he does not have an employment relationship with those clients, his employment relationship is only with the firm itself, does everything else still remain true? Does it have the same meaning if you change the word contractual to employment?
You're talking, this would be the first full paragraph, Commissioner Ankers, on page 7, the last sentence that says his contractual relationship will be only with the firm itself. I think that...
And the reason, well, I'll give you another minute to think about it, is that I don't expect that most law firms have, as lawyers, a contract with their clients. And I would expect everybody in my law firm to abide by that contract that my firm has with that client. And so I just want to make sure that it's not a nuance of the word contract versus just being he's an employee, but he's still bound by all of the same requirements of the relationship that the firm has with the client. And so in some ways, I just kind of thought, it's almost like a test for me. If I can read that paragraph and put the word employment there instead of contractual, does it still have the same meaning? And I think it does.
I see what you're saying, and I would not have a problem putting in his employment
I'm not asking
and
you to
contractual.
change it, Mr. Schaefer, at all. I'm more trying to make sure that the intent is the same,
Yeah.
whether it's contractual or whether his relationship is contractual or just employment.
The question that I was trying to address there was whether or not he is in privity with any of these entities that are these clients of his law firm. And to me, he wouldn't be employed by the clients of his firm, but the question is he in contract with them? And the reason I was focusing there on contractual relationships is that was keying off, like I said before, off the bar rules that talk about contractual privity. So I see what you're saying, but I think the question there is, does he have a contract with the clients of the firm? Is he in contractual relationship with them?
I agree with the language of the opinion, and I also think it's well written. It's just tricky because I think we all know that anybody who has a relationship with a law firm, whether it's contractual or employee, they have a relationship with the client, whether with the person's a lawyer or an employee of the firm. They have a relationship. But I still don't think that changes the intent or the meaning or the interpretation that we give the law, and I think what you say here is correct.
And I wanted to be careful too, you know, if we go too far down that road, we don't want to make the janitorial staff or, you know, secretaries at the firm to create any questions about whether or not they're, well,
I mean, really, you know, there's lots of confidential stuff happening among them. There's lots of sensitive information. But I realize that that's not the purview of the bar, and that's not the part of the opinion. But I do, just as a general matter, you know, do think that all employees of the firm should be held to the same standards. They don't have to file financial disclosures just because their boss might. You know, they're not held to all of the same standards. But by and large, I didn't want to give too much loose language to the people in the firm simply because they are not the ones who sign the contract.
Anybody else have any questions?
I have a question. So what struck me is when you were talking about his salary, and I'm looking at the document of where you all asked if his salary is flat, was the reason for that question because you wanted to see if he was getting commission off of the relationships he was obtaining in building? I mean, I would think that's the reason. So I just want to point out, because you said so flat, well, he's just getting a flat salary. However, it's his, I mean, he's getting a benefit. He is getting paid. And then the answers say that he also is, on here it says he can get bonuses. And so, yeah, he's getting a flat salary. Maybe he's not getting commission for bringing people in, but I don't think it's clear if he can get bonuses. And I don't know if this is even relative to the final decision here, but I think it's important to point out and be part of the discussion, because it's not just his firm benefiting, it's also him that could benefit. I mean, I don't know what these bonuses are based on. Maybe it's on the relationships he's built because of his position.
thank you, Commissioner. That's a very good point, and I did not mean to gloss over anything regarding that. You know, the reason that we asked that particular question, you're absolutely right, is he getting any type of perks or commissions based on the number of clients he gets and retains? The answer was, from what we were told, that he is not. He can get bonuses, as you pointed out, but I believe the response says he has the same possibility for a bonus as any other employee at the firm. Now, you're right. I'm assuming if he does a good job for the firm, he's probably going to be more prone to get bonuses than anyone else. But I still think I would stick to my recommendation that there's no clear and automatic incentive for him here to decide matters in these cities' favors if he goes to work lobbying for them. So I don't think that changes the analysis, but that is a very good point.
Okay.
You've used the term automatic, like it's not an automatic conflict several times, and somebody else used it too. Do you think that it might be, since that seems to be the basis of, or you know, the sort of bottom line analysis, do you think it might be useful to just use that phrase in here if it's not already, and say if this analysis concludes that there's not an automatic conflict by virtue of this relationship and this arrangement, but you know, and then because then it kind of leads naturally into the fact-specific examples and hypotheticals that you give at the end.
I certainly can. I think, you know, to be clear, I think like I said, the first part of 112.313 subsection 7A is very mechanical. You're either in conflict of it or you're not if you meet the elements. The second part is more situational. So perhaps I was a little bit too loose in saying that there's no, in kind of implying that the second part of the statute was mechanical in any way and there was no automatic conflict. Right. The second part of the statute really does hinge on the facts of each individual situation. But if it make you more comfortable, I certainly can put, if Steve agrees,
yeah,
you know.
Just to make sure I'm understanding so that it goes out the way that you want it. What you're saying is, as presented, the facts as presented don't amount to a conflict, but these other circumstances that we're concerned about and we're cautioning about, those could?
Right, I think that sort of makes it clear to answer some of the questions that have been asked today, which is, you know, this, and I understand this is how all of these opinions work, but just to make it clear, since it is, you know, there's a lot of hypothetical discussion, and if the facts were different than this, to make clear that the bottom line opinion is that we are saying that these fixed facts do not give rise to an automatic conflict. And so all of the other things that we're talking about are cautionary tales.
I think the top of page 15 might be a good place to put that in. Okay, like you said before I start talking about the different, you know, things, the different ethical statutes that he'll have to make sure he continues to comply with.
Yeah, and I think that's a really helpful analysis at the end. I've got a couple. I'm just going to drive everyone crazy for a few minutes if you guys will indulge me. I just had a couple questions and comments. On page, with regard to the stay, footnote 2, I want to make sure that it's completely up to date when the opinion goes out. Was the motion to stay filed in the district court or in the appellate court or both?
Filed in both. The motion to stay at the district court was denied, allowing us then to go, when I say us, the Solicitor General is representing
Right, then you
and the
can
two other
move in the
defendants in
appellate
this
court.
matter. The Solicitor General has filed that stay now at the 11th Circuit.
Right, and it hasn't been ruled on yet?
No.
Okay. They've been very slow on motions to stay. Okay, as long as that's, because that's obviously a huge factor. So as long as, that's the last thing we check before we click publish. And then on page 5, when you cite the bar rule,
Right.
I think it's did you mean to cite 4-5.8A rather than 8.8A? Because that's the 4-5, I think, is the rule that deals with the dissolution of law firms and the ownership of client files when someone leaves the firm, which I think is the language that comes from.
We can check that.
I just want to make sure it's the right citation.
I don't have that in front of me, but I can make sure that's the right citation before the opinion is issued. And I don't know that I have that printed off here either.
Check 4-5.8 and see if, compare that to the citation and see.
Okay.
Make sure that that's the,
You have-
I'm looking for it right now. When I have it, I'll jump in.
I guess it's to avoid while you look. The only other comment I had, or question, comment, what have you, is on page 7, when we turn into the second part.
Mm-hmm.
I mean, and it really gets into, when we get into the bottom of page 11 and through page 13, when we're analyzing that second part of 112, 13.7a, or 313.7a, we're obviously all very familiar with what the second part of that means. I think laying out the statutory language of what we consider the second part would be clear, make it more clear to the public what language we're talking about. And the reason, what made me think of that is when you look at page 11 through 13, talking about when you're applying that statute, the analysis, I think, is spot on, and it's extremely well written. I think the first meeting we were here, I told you that I thought, what an excellent advocate I thought you were. It's very well written, but I do think that it comes across when we're analyzing the interface maybe between the county and the municipal clients would be limited or would be infrequent. It's almost phrased like that's an equitable consideration, and I think it's important to make clear that that's a statutory requirement, right? It's a statutory consideration that the interface would have to be continuous or frequently recurring in order to give rise to an issue. And so my suggestion would be to highlight that statutory language before getting into that analysis to make clear that this isn't just like an equitable balancing test.
Mm-hmm.
It's the statutory language that we're applying when we say these, if anything comes up, it's going to be infrequent, or the interface between the client and the county would be limited. And that was very rambling, but you kind of understand the change that I'm suggesting?
I'm not quite clear. I mean, we do
I don't
cite
blame
the
you.
statute on page 4,
So-
the entirety of it. Now, on the second part of 7A, I will say can be triggered. There is language about a continuing or frequently occurring conflict, but there's also language that it can be anything that would impede the full and faithful discharge of your duties. And I do know that we have cases that say it could be just one instance that might tempt you to compromise your duties. So certainly, looking at the frequency of the contact between your clients and your agency, that's definitely a consideration to weigh. I don't want to take anything away from our prior opinions, though, that say that even just one instance can, in certain circumstances, be enough to find a conflict, though.
I think just if the statutory language was cited,
Oh.
and spelled out.
So you'd like me to cite that second part of the
The
statute
full
again?
part, I think that would,
Okay.
to make sure that that's clear that that's the language that's being applied.
Okay, so right around there, page 11 to 13, just cite the second part of the statute again.
Yeah,
Okay.
you use the actual language. That's,
Okay.
Madam Chair, I did find that you are right about the rules regulating the bar,
okay.
4-5.8.
Sorry for being so nitpicky. I think that was my last comment, and thank you for indulging me, I appreciate it. Did anybody else have any questions or comments? Okay,
Move the adoption of the proposed opinion.
did, is it Mr. Elliott? Was there anything that you wanted to say?
No, other than thanking Mr. Schaefer for what I just read the opinion yesterday for the first time. My partner down in Melbourne with the name I'm interfacing on this. Anyway, excellent presentation, that work and that research on very intricate areas of the law, both and factually and all the different factual scenarios. So excellent job. I'm really glad I didn't have to do all that research. And I'll also want to thank the commission, obviously, all good questions and good responses. I appreciate it.
Thank you so much. So that was a motion to adopt.
Second.
Okay, and that's just to clarify with the few little.
Recommended changes.
Okay, all right, all in favor?
Aye.
Thank you so much. Thank you. Okay, moving on to item number 8, consideration of financial disclosure appeals. These are appeal numbers 20-057 and 21-004 in Re Mark St. Ville. The appellant did not request a hearing. Are there any questions from the members, or should the staff attorney present the draft orders?
People walking up, Madam Chair.
I'm sorry? Oh, yes.
Good morning, I'm Mark St. Ville. And I am not sure, apologies, I didn't have a chance to.
Oh, one moment.
Sure.
Okay, so let's do it this way then. Thank you for, let's do it this way. Let's have Mr. Schaefer present the draft order, and then we'll have questions for him, and then Mr. St. Ville, you'll have an opportunity, and we'll have questions for you, and then we can move forward. I apologize for
No worries.
making you jump up and down. Is that right? Thanks, Gary.
Thank you, Chair. There were two matters here that were disclosure appeals from Mr. St. Ville. He is a member of the Planning and Zoning Board for the City of Miami Beach. I guess I'll take them both together. There's two appeals here. One of them pertains to a fine of $850 for failing to timely file his 2019 Form 1. That's appeal number 20-57. The other appeal is 21-004. It relates to a $1,500 fine for failing to timely file his 2020 Form 1. Now, when we look at disclosure appeals, you have the ability to affirm the fine, waive the fine, or reduce it to any measure that you think is acceptable under the circumstances. Now, let me look at the appeal here for the 2019 form first. That would be appeal number 20-57. When you're considering an appeal, what the appellant is asked to deliver is to explain unusual circumstances that caused his late filing, which is defined, I believe, in the statutes and the rules to mean some kind of type of uncommon, rare, unforeseen circumstance that prevented their failure to timely file. Now, in his notice of appeal regarding the 2019 form with a fine of $850, Mr. St. Ville has indicated, and this is, I'm just going to read you directly what it says. If memory serves me correct, the director of the Planning and Zoning Department advised and provided a copy of the disclosure. I see the actual 2019 submittal was delivered after the grace period. I apologize for the delay in doing so and request a waiver of the accumulated amount. Now, when I reviewed that, it didn't seem to me to raise any reasons, though, why he did an untimely file. He acknowledges the fact that he received the form. He acknowledged the fact that he filed the form after the grace period expired and was accruing a fine, and he apologizes for that delay. So because of that, I just didn't see any unusual circumstances there to justify recommending that you waive or reduce the fine, so I recommended that you affirm the fine. So that's for the 2019 appeal regarding the $850 fine. That's Appeal 20-57. The other appeal is Appeal 21-004, which is a $1,500 fine regarding the failure to timely file his 2020 Form 1. Now, for that particular form, I am recommending that you waive the fine. He asserts that he didn't receive timely notice of his filing obligation. Usually, if a filer is raising the defense in an appeal of a lack of notice, that raises some due process concerns. And even if they filed in the past, we kind of treat each year on a fresh slate. Lack of notice is the commission has found a legitimate reason to find unusual circumstances waiving a fine. Now here, there's no evidence to dispute his claim of lack of notice. There were 3 notices sent to him, according to our records, prior to the expiration of the grace period when he started accumulating the fine. He got an initial notice from the Supervisor of Elections. He got a postcard from our office. Those aren't sent certified, so we can't confirm whether or not he received them. But the SOE also sent him a certified notice, and the Postal Service indicates that certified notice was not ever delivered. And so he's claiming that he did not receive notice. We don't have any evidence to dispute that. And indeed, the certified notice that he received was never delivered to him. So based on that, it seems that there are unusual circumstances, and I recommended waiving the $1,500 fine for the 2020 Form 1. I'm happy to answer any questions if you have them.
Does anyone have questions for Mr. Schaefer? Thank you. So we didn't receive a request for a hearing, and so that whatever the order ends up being would need to be revised to accurately reflect that because Mr. Sayville is here, and we're going to, we'll allow him to say his piece as well. So, Mr. Sayville, if you want to come on up.
Good afternoon. Apologies for that, for any part that I may have played in not properly setting that hearing. I did not know whether or not you guys had capabilities to share what's on my computer. I did prepare a PowerPoint, but that's fine. I apologize because I know him as Ron. Your last name is?
Schaefer.
Schaefer. Mr. Schaefer and I have communicated, I apologize, Mark Saintsville, addresses of 1000 Northeast 160th Street. I am the current chairman of the Planning and Zoning Board of North Miami Beach. I've been a member of the board since 2018. The reason I'm before this board today is because, as Mr. Shaver has outlined, there was a discrepancy with my financial disclosures. I did prepare a PowerPoint that kind of outlined the time frame, but the more egregious allegation, if you would, is what he's recommending a waiver for, and that's based on the concept of failed notice. I echo those sentiments. I also believe that a waiver should be granted as it relates to the subsequent violation, which I believe is the 2021 violation, which is a lesser amount, I believe in the amount of $850. I did want to highlight a couple of facts, and just to give you the lay of the land of the Planning and Zoning Board as it relates to how things operated before my arrival and since my arrival. And these are some of the facts that, I kind of had in my PowerPoint. It's not going to be able to be seen. But in 2018, the Planning and Zoning Board met for a record 4 times. The Planning and Zoning Board is supposed to meet at least 10 times or have 10 scheduled meetings in a calendar year. In 2019, I became a member of the board, and that was the first time in the last 5 years that it met all 10 times. And like I said, I started as a board member. I currently serve as the chairman of the board. What's happened since joining the board? Okay, from 2018, we went from 4 meetings to 10 meetings. Since 2019, the most consistent body of board that we've had in the last 10 years. Since 2019, there's been 47 scheduled meetings, 37 of which I have attended. Of those 47 scheduled meetings, 4 meetings did not take place for lack of quorum. In the 4 years that I have been on the board, I have missed 4 meetings because of travel, one way or the other. There's been 3 planning and zoning directors, and this is what kind of touches into what I responded in my appeal. So I know at some point the planning and zoning director would give us a nudge or a reminder or something to say, hey, listen, make sure you get your financials in. And I assume that in 2021, at the transition of a new planning and zoning director, whenever that notice came about, it had already passed the time frame. I know that we're looking at it anew, or de novo, if you would, for each calendar year that we're supposed to send the financial affidavits. So when I received that notice or reminder from the Planning and Zoning Board, understanding that it's not their responsibility, but it was something that had common practice, if you would, when I received that notice, I went ahead and filed, but that, of course, I understand that there was a tardiness in there. But I just want for the board to understand that in addition to serving on the Planning and Zoning Board, I'm an active member of the community. So there are several inserts that highlight different activities and engagements that I've done in the community, be it back to school drive, be it Halloween giveaway, holiday giveaway, turkey drives. I'm an active member of this community, so much so that August 31st of this year, I was awarded or recognized what marks St. Ville Day. So I'm not someone who's flying by night, who's trying to circumvent the rules and responsibilities of the board. I take my role in the community very serious, as though I take my role on the Planning and Zoning Board. So in light of everything that's been presented before you, granted you don't have the benefit of seeing the videos, I just wanted to paint a full picture, a robust picture of what has occurred and how we came to this point. I do require or request and prayer for relief that you guys would reduce or waive the entire 2021 fee. I know that the statute says that upon receipt of the disclosure statement, and I'm quoting, upon receipt of the disclosure statement or upon accrual of the maximum penalty, whichever occurs first, the commission shall determine the amount of a fine which is due and shall notify the delinquent person. The notice must include an explanation of the appeal procedure under paragraph 2. Such fine must be paid within 30 days after the notice payment is due unless appeal is to the commission pursuant to subparagraph 2. I read all of this for this one sentence. It says the money shall be deposited into the general revenue fund. And this is my first time at the Court of Appeals. This is a lovely building, one of the best courthouses that I've been to. And while I would love to support the general fund, I think my community would love me to continue to support them a bit more. So if you guys would take that into consideration and waive the 2021 fund, I would happily accept that and make sure that I take full onus of getting those financials in on time moving forward. Thank you.
Are there any questions?
I have a question for Chair or someone. Oh, not for you, sir. It's more of a procedural thing. I don't know what our authority.
Should I stay?
Oh, that's up to the Chair.
Oh, you can take a seat. Thank you very much for your presentation.
Just what is our authority and flexibility to adjust the amount, or do we have that ability to do that as a board, to have that discussion?
That's a Steve special.
Oh, sorry.
Happy to answer that.
One day I'll be able to answer that question. Today's not.
Through the chair, the statute that for appeals of financial disclosures allows you to do 3 things. You can waive the fine, you can reduce the fine, you can affirm the fine. For us to waive or reduce the fine, there needs to be a finding that unusual circumstances prevented the filing. And so usually in a situation where we're reducing, it would be because if he was late 20 days, 10 days, there was unusual circumstances, but maybe not for the other 10 or something like that. For a waiver, we would need to identify in the decision, in the final order, that there were unusual circumstances that prevented it. And so those are your 3 choices.
So very clear guidelines, unusual circumstances. We can't just say, he seems like a really nice guy and we would like to reduce or waive. Is that?
That's right.
Okay, thank you.
I want to make sure that I have my understanding correct. So for the second year, the later year, the 1,500 was lack of notice, and so that's a recommended waiver.
That's
For the
correct.
first year, and Mr. St. Bill, I told you to sit down, and I shouldn't.
Oh,
You
gosh.
don't have to come all the way back, but I do have a question. Is the general position that you're taking is there was some shuffling and changing at the board, and ordinary practice was that somebody was administratively helping make sure we got these things filed. For whatever reason, that didn't happen this year, but as soon as you realized that sort of ping didn't occur, you corrected it?
Yes.
Okay. Okay.
If I may, Chair, at the zoning and planning, I know this shouldn't matter, but it's a volunteer position?
It is.
And is it Miami? Is that what? North Miami, okay. I've served on a zoning and planning, and it's not as structured and organized as this. You don't get your information presented in the formalities you do here. So, I could see how stuff gets lost in the fray if they're having that much turnover.
Thank you. What is the, how do they come to the number, dollar amount for the first fine?
If a filer, through the chair, if a filer is late, meaning they don't turn the form in by the expiration of the grace period by September 1st, the statute says they accrue a fine of $25 a day, up to a maximum of $1,500. So in the first appeal regarding the 2019 form year, he accrued an $850 fine. I'm not sure how many times 25 goes into 850, but that shows you how many days that form was late. The second year, where I'm recommending a waiver due to lack of notice, he accrued the full $1,500 fine of $25 a day after September 1st.
So it was 33 days late, the first one?
Yes, if 33 times 25 is 850.
How about everyone else on the board at the time? Do we know where theirs filed timely?
That I do not know, but what I can say is this came to light, or we're talking about the 2021, the one that's still in contention. I can't speak to that. I can't say with any confidence.
And we don't know internally? Just curious.
Through the chair. I mean, we would have those records back at the office, and we would have.
Something I should have asked prior than this meeting is what you're saying.
We don't have those in the
Got it.
record before us. But the commission does notify filers in May, a certified mail in July, and a postcard mailing in August. So we do everything we can to track them down. I do know at the local level, there are a lot of municipalities who have coordinators and folks with the boards who do work with us and kind of ping those board members to urge them to get it in, because we can't stop the fines once they start.
I got another question. You spoke to, for the attorney, you spoke through, have to have a reason to waive it. What about reducing? Is there another thing for reducing?
Commissioner, I'm sorry, I couldn't hear you.
You spoke to that you have to have a statutory requirement to waive a fee. What about reducing the fee?
You can reduce a fee if you find, again, that there's unusual circumstances. As Steve explained, you can affirm the fine, or if you find there is unusual circumstances, you can waive it completely, or you can reduce it to any amount you think is proper.
Would you mind stepping up so we can hear you in the microphone? Sorry about that. Thank you.
Not to speak directly to that question because that's not within my purview, but I did want to bring into the board's attention in researching and preparing to be here today. There is a distinction. The statute in 2018 reads what notices or what efforts are made, and it says that in May 1st, they would contact all members who sit on the board, something of that nature, via their mailing address. And the more recent one says mailing address, email, and physical address. So the statute itself has been updated to have a broader net on ways to try and get notice to the individual. Mr. Swery could attest, as soon as he reached out via telephone and email, I was very responsive. With the matter that he's recommending complete waiver for. I know that doesn't address what goes on with the 2019, but I just wanted to bring that to the attention, that notice is going to be, people who serve on these planning and zoning boards aren't people who aren't interested in following the letter of the law. But if whatever methods that we're doing to make sure notice is received, I just want to put that out there. Thanks.
I have a question, Madam Chair.
One moment, please.
Here's my position on this. I've not heard anything unusual or mitigating. When I was state attorney, I used to just go insane when one of my lawyers would stand in front of a judge and blame something they had done or not done on a secretary or something else. Blaming somebody else doesn't cut it with me. When there was an opportunity to say whatever problem might have existed, there was no explanation given. I moved acceptance of the order on 2019, in other words, imposing the $850 fine, as well as acceptance on the 2020 fine of waiving the $1,500.
Second. Before we vote, was there another comment or question, Commissioner Newton, that you had?
Well, yes, I had a question for the gentleman before he sat down.
Okay. And then, we'll take the vote.
When did you receive the 2019 notification for the Form 1 or Form 6? Am I saying it right? Which Form 1? Get it right.
If my memory serves me correct, we got that nudge, as I suggested, from the new planning and zoning director when that transition happened. But there was a meeting that was missed, so I don't know if that's part of the 30 days. But I know when the new planning and zoning director, he said, hey, make sure that all the financials are turned in. Like, oh, okay, so I turned in my financials. So I'm not exactly sure when the time frame was, but as soon as I was advised, I did it in short order. That they were pending, I did it in short order. But I don't know what happened between the deadline from when it should have been submitted to when that nudge was provided. And, yeah.
Follow-up question, Madam Chair. And you've corrected that process, you said, on the board?
Yes, sir. Not only have I submitted both of the Form 1s for the 2021 and 2020, I've also updated to receive all communications from the FEC to my business address, which never has any hiccups. So I don't foresee it being an issue moving forward.
Thank you. Madam Chair, I'd like to pose a substitute motion, if I may. Just splitting the baby, if you will. Obviously, there was some disconnect between the time he got notified as a volunteer member of the Form 1 filing process. But once he got notified, he said he filed it. And I did the math, it was 33 days to be exact. So I would like to make a substitute motion that we do a reduction, say 16 days of $400, because the problem has been mitigated and has also been fixed. So there shouldn't be any problems going forward, if that would be acceptable. So $400 fine for the 2019 one and waiver of the second one as recommended by staff would be my substitute motion.
Okay, is there a second?
Second.
Okay.
Madam Chair, may I ask a procedural question? And I admit I haven't brushed up on my parliamentary. And I don't know if you know, when a substitute motion is made and seconded, does that just get to vaporize the first motion?
So
and second?
the way that
Or
I'm,
can't they just vote against it?
I think that's and I think that's a good question, because the way that I was thinking about this in my mind when you said that was it almost like,
I could
pick
answer
the
it.
one you want.
I could answer
And
it.
I don't know the answer to that
According to
question.
parliamentary rule, you have to deal with the second first. If the second is successful,
Well-
then it would prevail. But if not, you go back to the original motion. That's
Let's-
parliamentary rules.
What's
Or you
Florida
can
Commission
legal-
on Ethics
legal do it,
procedure?
Yeah.
Do we have a
So,
parliamentarian?
we don't have a rule on this, and you have not formally adopted Robert's Rules of Order by any
Oh,
other
okay.
means.
All right.
However, in the past, what you have done is if there's been a motion and it's been properly seconded, and then you go into discussion, and then somebody else makes a substitute motion, and that's seconded, what you've done and what actually Robert's Rules of Order says to do is to vote as to whether or not the substitute motion will replace the original motion.
Okay, that seems fair.
And then, pass or fail, then you are voting on the merits on the second vote. So if the substitute motion has substituted for the first motion, then you will vote to adopt it or not. If the substitute motion fails, then you're back to Commissioner Servone's original motion.
Okay, which that sort of operates. Okay. Does that make sense to everybody?
No.
No?
Yes, it makes sense, yeah. Don't know
Well,
that
I
I
mean, I
like it,
think
but.
that, and I think that this is, obviously, this is fair. We've got a lot of new faces, and thank goodness for our wonderful legal counsel, but, I mean, there's two competing viewpoints here on how this should be handled, and I want to do it in the most equitable way possible, and I probably messed it up by, saying substitute motion, but I think it sounds like if, we'll vote on whether or not the substitute motion will replace the first motion, which, I mean, that's kind of operates as on the merits. So why don't we take that vote now?
A comment on the substitute motion?
Certainly.
I might be more persuaded had there not been another problem the next year. For that reason alone, I am not persuaded at all to do any sort of reduction. So I will not vote for the substitute motion.
Okay. So then, let's call a vote on whether or not to accept the substitute motion in lieu of, to vote on the substitute motion in lieu of the original motion. All in favor of that, say aye.
All right.
And opposed?
No.
Okay, so then we're back to the original motion, which is to accept the recommendation from Mr. Schaefer as to both years.
Yes.
Okay, all in favor of that motion?
Aye.
Aye.
All opposed?
No.
Okay. So that the recommendation is then approved? Yes. Okay. And just so, to make sure that the orders that were proposed are, just tweaked to reflect that the appellant was able to make statements as well. Okay. All right. Thank you, Mr. St. Bill, for being here.
Thank you for the opportunity to speak. I just wanted to, I know that the board has voted, but out of curiosity, why would the subsequent year affect the 2019 analysis of every year that's taken a year as a review?
Unfortunately, the vote's already been taken, and that sounds like, and if two private citizens want to go have a drink and hash it out, then I think that that's perfectly acceptable. But the vote has been taken, and we really appreciate you being here and advocating on your own behalf. I meant a coffee. So I think next we're going to move into the budget. Is there a preference that we take a 5-minute comfort break before we do that, or does anyone want to go ahead and power through?
Why don't we finish this agenda before
Okay.
we break?
All right, I didn't want to be selfish. All right, so item number 9 is consideration of the proposed fiscal year budget. Ms. Stillman prepared a draft proposed budget, which was provided in the supplemental mail-out and is in our materials. So I'll recognize Ms. Stillman to walk through her plans for the commission's upcoming budget request for the commission and the commission's executive branch lobbyist registration trust fund, which will be subject to change depending on instructions from the legislature. After questions and discussion, we'll vote to approve the proposed budget in concept with the understanding that some of the information in the proposed budget could change based on more updated information provided in the parameters set by the legislature. So go ahead. Thank you.
Thank you. Good morning. Thank you, Madam Chair. As you all know, the Ethics Commission is constitutionally independent, but we are administratively housed in the legislature, and staff are legislative employees. So as with all legislative agencies, we receive instructions from the House and Senate related to our budget requests. This budget request will be for fiscal year 24 to 25, which is hard for me to go that far forward today. I'm still working on doing 2023. Once those instructions are received, I'll assemble our official budget request. The turnaround time to meet the deadline is usually pretty quick, and that's why I have this draft proposal before you today, because I'll have to work it really quickly once I receive the information. I work with the Office of Legislative Services to assemble the necessary information. They help me verify certain calculations within the budget and provide me with a lot of helpful information as we put it together. Historically, the commission has received the appropriation that it has sought. We've not had to lobby the legislature relating to our budget requests, given where we are housed. We receive a lump sum appropriation for the commission and a lump sum appropriation for the executive, regarding the Executive Branch Lobbyist Trust Fund. We break the budget request down into 3 categories: salaries, OPS, and expenses. We'll go through executive branch first, and then we'll move on to the commission's request. So, as I mentioned, the commission administers the executive branch lobbyist registration laws. And so we have an executive branch lobbyist registration office. It is co-located downtown with the legislative branch lobbying office. We have a split with the legislative branch. The executive branch split is 48% of the office costs, with legislative being approximately 52%. This funding for the office is through a trust fund. It is funded from the lobbyist registration fees of $25 per principal, and the late compensation reports where they pay $50 a day for each day their lobbyist compensation reports are late. Registration to lobby and the compensation reporting is done electronically. We have one employee in that office. She is the executive branch lobbyist registrar, and she is fabulous. Her name is Karen Murphy-Funton. Our budget for that office remains generally consistent. The largest amount, if you look at this fact sheet that's on your first page, it's a look at, you can see fiscal year 22-23, budgeted and actual. You can see where we are currently and what we're projected to end up with at the end of the year. And then finally, fiscal year 24-25, what I am presenting a draft to you today and a proposal for fiscal year 24-25. You'll also see on that page any carry forward funds from previous years, and down in the shaded portion in the bottom, any requests for carry forward dollars. So to get in the actual operating budget, you will see that the salary amounts as compared to last year is reduced. That is because historically, Executive Branch Lobbyist Trust Fund has transferred fund to the commission for salary support in the amount of about $55,000 a year. I anticipate that amount can be reduced, so I'm only proposing a $25,000 transfer to the commission's budget. That offsets the work that our legal staff, as well as Steve and myself, do in relation to executive branch lobbying on an ongoing basis. Although we're not located downtown, we work closely with Karen on a number of issues that do come up. But given that everything is electronic now, it's very streamlined, and so we see a little bit of a reduction there. Under the OPS category, you'll see the largest amount that is proposed there is for what's called accounting or auditing services, and I've proposed $70,000 in that particular category. That is for the lobbyist audits. Those are random audits that are done each year. They actually have a random drawing that takes place downtown. How much those audits cost depend on which firms are randomly selected. The larger the firm, the higher the auditing costs. I have no way to predict what firms will be selected. So I didn't just pull $70,000 out of thin air. That's roughly the average of the last 5-6 years worth of audits. I've also requested permission in the fact sheet and carry forward dollars, that if $70,000 is not enough, that the legislature allow me to use carry forward dollars to pay for those auditing services. Some years they're low, some years they're really high, so that is the number I went with and the reasoning. As for the expense category, you can see it's nominal cost. We try to be good stewards. The highest amount that's reflected under expenses is for the lease of the space in the Pepper Building. If the lease amount goes up by DMS, then the trust fund will receive administered funds to cover that change. And so you see the total requested appropriation at this time in the draft is $191,128.
Oh, question.
Yes.
Where are you getting property insurance for $19? You probably want to go to the legislature and let them know. 'Cause that's pretty good.
I
And I wanna
cannot
know.
I cannot take credit for that. That amount is given to me. I am told what amount to put in the budget, so that comes from accounting.
No, on page one, when you look at you got your FTEs up there and you're vacant, you have a .5 for a vacant FTE, but then, and it goes away in subsequent years. Is that
Yes.
Is that the transfer money that's represented?
The .5 that shows a vacancy in 22-23, we did away with that position in past years when registration and reporting, we had expenditure reporting, it was quarterly. We had a few employees there, we gradually whittled it down, and we now just have a one employee.
Okay.
And we don't anticipate a need for an additional employee at this time unless the law.
Get that
unless the law
property
changes.
insurance information to me.
I am in the same boat, I would appreciate that. There is a shaded area towards the bottom of the operating budget, and I wrote a bunch of TBD on there. Those figures are supplied to me by the fiscal office downtown. Once they have those numbers reconciled and I present the proposal here, they fill in those numbers, so I don't have those numbers at this time. So that completes executive branch. I don't know if you want to discuss it and do a motion on executive branch now or wait until after the commission portion, but that is up to you, Madam Chair.
Well, does anybody have questions on this portion? We'll just handle it all at once at the end.
Okay. Moving on to the commission's budget, you have the same types of information before you. You have the fact sheet, which is a three-year look. You have an operating budget, and I've also attached a list of our contracts that we anticipate having and current contracts that we have are the last page of the packet that you have received. You'll note that there aren't significant differences between the requests from year to year by the commission. That is what they refer to downtown as, I think, a continuation budget. We work very hard as your staff to be good stewards of taxpayer dollars. We try to be very careful there. We have come under budget each and every year, and I'm thankful for that. I do not want to have to go downtown and ask for a budget amendment. So we're pleased to come in. Obviously, the largest category for an agency such as ours is the salary category. I have the salaries broken down by types of employees. You will see the executive branch reimbursement to budget of $25,000 reflected there. You'll also see a personnel plan within the salaries budget. Within the personnel plan, I look for the ability to make adjustments if we have a member of staff who has a qualifying status change in terms of benefits. Sometimes we have to use funds from the personnel plan to pay out leave payouts if someone terminates employment or retires. Sometimes that happens out of carry forward. I wait for instructions as to that, but also any type of merit increases for any member of staff would come out of that personnel plan. I do not believe that we will have any anticipated staff changes based on what I know right now. and hopefully, I say that, we will have some staffing related to e-filing, but that will be separate and apart from this budget at this time. I don't anticipate any permanent changes to staffing levels in the 24-25 fiscal year. So you will also note on the fact sheet under the carry forward amounts at the bottom of the sheet, you'll see a TBD next to contractual services and a TBD next to leave payouts. I anticipate that I will need to ask for some funds, carry forward funds. I'd like to ask for, and I would request your support for, requesting that the legislature give us flexibility in the use of our carry forward dollars in relation to the implementation of the e-filing system. We do not know yet how much we're going to need to expand or contract. We're going to have some additional mailings that we have to do. Even though the system is electronic and it's based on emails, I'm willing to bet that based on email bounce back and just sort of a belt and suspenders approach, we may need to do some mail outs to kind of work everybody on board in these first few years. So that would be under contractual services. Leave payouts, again, if the instructions are, if we have leave payouts to make, I would request flexibility to be able to do that out of carry forward instead of the actual operating budget. So moving to the OPS category of the budget request, you will see the largest item in there is legal services general. That is our main contract with the Office of the Attorney General. That is what funds our Office of the Advocates. There are currently 3 employees within the Advocates Office. The Office of Attorney General lets me know what their amount will be for the coming year in terms of that request. And this year, they made a request and then asked for a 7% increase on top of that request to deal with potential salary issues. In addition to that, I have additional monies in that category in the event, given our increased efficiency in our office and caseload for the advocates, I put some additional funds in there to give some flexibility in case they need additional support staff to accomplish their goals in that office. The next line is $50,000. That's under legal services. That is in case the Office of Attorney General has to conflict out on a particular case and we need to get a special advocate. Those monies also come into play if lawsuits are filed. We were litigation heavy this year. We had, I think, a rules challenge, and of course we've had the federal litigation. So those monies are there in case something like that happens. The rest of it is, I think, pretty standard within that category: legal advertisements, records management. There are potential credit card charges when people pay their fines. We have to pay credit card fees and equipment maintenance. So that category is $614,220. And then we move to expenses. Within the expense category, of course, our largest expense is our building lease, which you have already approved. That tends to be the largest expense, followed by the travel category, the travel to have members travel to meetings, travel for our investigators to travel throughout the state and investigate complaints. Postage keeps getting raised. I might have to tweak the $20,000 amount that is in there for mailing. We also have a connectivity fee for our Suncom data circuits. You'll see that comes in at about $11,300. There is, in addition, I don't want to miss this. There is an out-of-state travel budget that's noted as about $7,000. That is generally so that 1 to 3 commission staff members would be able to attend the annual COCO conference. That's the Council on Governmental Ethics Laws. It is an association of government ethics professionals throughout the United States, Canada, and the world. They cover enforcement, ethics, elections, campaign finance, and public records law. It is, and I say this with a lot of love in my heart, it is a conference for ethics nerds. And there's a lot of species recognition there. It's really the best professional development that we can get. It also informs us as to what's happening in other states as well as trends that might be happening. So we always like to send a couple people if we can. So I have budgeted for that. Information technology services, software licenses, the meeting materials come in Alchemy. Those are software licenses that we have to obtain. Of course, Adobe, all of your basic Office software licenses. The other large item are the subscriptions and online, for online and electronic subscriptions. That is mainly the Westlaw contract, and you'll see that on your contract list for those of you who are lawyers. You know that is a necessary thing. In 24-25, we'll be in our third and final year of a 3-year contract. We'll have to renegotiate that contract for subsequent years. I've added a little bit more in that category because we will be adding another attorney to our staff who will need to have the ability to conduct research. Moving to special categories, under administrative hearings, $42,116 is the amount that the Division of Administrative Hearings has requested with regard to the cases that they hear for us. This is a significant decrease from last year. If you look at your fact sheet, I believe last year it was $166,000. We are significantly lower this year. Last year, the way they calculated our cases was different than the way they calculated them for this year. They were kind enough to take a meeting with me last year where I worked with them and sort of the unique nature of our cases. And so they revisited the amount, and I'm pleased to report that it is much, much lower this time. And again, the insurance anticipated at $3,726. That's the number they gave me. Of course, that could change. I do want to note about contracts and just remind you that my expenditure authority is limited to $10,000. So when you see contracts on this list, anything that's over $10,000 has come before previous commissions to be approved. Any subsequent contracts that could arise, such as a staffing contract related to e-filing, would come to you all if it is over $10,000. And so with that, I would ask your support for these proposed budgets, at least in concept, and I'm happy to answer questions that you might have.
Question. On page 6, the OAG line item for contract, could you explain the difference between why the multi-year line item is significantly lower than the single-year budget line item?
Are you on the contracts list?
Yeah, the OAG line item. 537 to 442 for multi-year.
That is, thank you, that is a typo. That's just remaining from last year. I apologize, thank you for bringing that.
Which one? What should it be?
It's each year it's a 1-year contract. We re-sign the contract each year and you approve it. It is the $537,742 that I'm asking for.
So there is no multi-year there.
There is no multi-year with
Okay.
that. That's just the way the spreadsheet is set up. So.
Okay. Are there any other questions?
I have a question.
Sure.
And it's the same, it's back with the FTEs. In the out years, you got 2.25 vacancies in 2023, but in the out years, you have none. But the total FTEs goes down. So what happened to the 2.25? Shouldn't it went up or got
We-
absorbed or?
In different years, positions were combined. Like I said, we are good stewards of taxpayer dollars. If we don't need positions, we will shed the positions. We did, due to obviously our litigation load that we've had and e-filing anticipated, we did ask in last year's budget for an attorney position, which was approved, and we anticipate filling that attorney position soon.
Commissioner Akers?
Thank you.
Carrie, on the Commission on Ethics fact sheet, under the appropriations category, the subset for administrative hearings, can you just walk me through the 2023-24 category and then the significant decrease for 24-25?
Through the chair. As it was explained to me, DOA changed the way that they were calculating costs for cases that they were handling. And they went, I think instead of time, they went to a per-case basis. The year that they were calculating that amount off of, the commission had a number of consolidated cases. I think one of them had 19 complaints that were consolidated into one. And when I received the number, I realized that they were counting each of the consolidated cases as a separate case. And when I realized that, it was still just one hearing, but as those cases came in, they were viewing them as separate cases. So after we met, they agreed that the way our cases come in are a little bit different, and they no longer count each consolidated case as its own case. They will count it as one, and that's why we see the reduction.
Are there any other questions on either of the budgets?
And if I could add just one more thing, again, I would like your support in requesting flexibility in those carry-forward dollars to deal with the e-filing project as we work through that.
So is there a motion to approve both for the
Second.
ethics,
Second.
the executive branch lobbyist registration trust fund, with the caveat that we're going to request flexibility to deal with carryover funds for purposes of e-filing? Motion, I heard a second. All in favor? Aye. Sorry, just want to make sure it's. You know you've got to make your record clear. Okay, so there's no chair's report. Carrie, did you have another
Yes.
executive director's report?
I do,
E-filing
I
update?
have, sorry.
All right.
I do have, and a little bit of legislative report.
Okay, great.
There wasn't one put out there, but I do want to update you. In addition to my written report, as you mentioned earlier, Commissioner Gates did resign. He sent a resignation letter. It was received after mail out, so I wanted to just put it in the record. It was addressed to Senate President Kathleen Passidomo. Madam President, and it's dated October 2nd. As you're aware, today I pre-filed as a candidate for the Republican nomination of the Florida Senate in District 1. I am currently serving as the Senate's appointee on the Florida Commission on Ethics. Although it is not forbidden by law, I believe it would compromise the independence and integrity of the Ethics Commission to be a candidate for public office and, at the same time, a member of the Commission. Consequently, I hereby resign from the Commission on Ethics effective immediately. Please know that serving on the Commission on Ethics has been a highlight of my public life. I am deeply grateful for this opportunity to work with an extraordinarily professional staff and committed, able commissioners of both parties. And it's signed respectfully, Donna Gates. In addition to that, we haven't added any staff, so I don't have anyone to introduce you to. But I wanted to let you know that legislatively, the recommendations have been provided to the legislature and to the leadership. There's not really been any activity on ethics laws, although there is one Senate Bill 102 that was filed by Senator Jones a few days after mail-out. It would create a new section of the Ethics Code that would apply to the insurance commissioner, identifying a 7-year revolving door prohibition for the commissioner to represent persons or entities for compensation before the Office of Insurance Regulation, or for them to serve as an employee or a contractor of a regulated entity for those 7 years. Senate Ethics and Elections is its second committee referral. There's currently no House companion. So aside from that, the only thing that I would ask is your help in finding sponsors. If any of you have relationships with members in the House and Senate, if you would reach out to me, please, and facilitate an introduction so that maybe we can get some bills sponsored for the commission. And with that concludes my report. I guess I go into e-filing. Okay, the moment you've been waiting for, the e-filing update. Again, we are in user acceptance testing for our e-filing system in preparation for that Jan 1 rollout of the Form 1 and the Form 2. Kim and Lynn have been embedded downtown with the OLIT's e-filing team each week, and they are making great progress. We're working with city clerks to determine early qualifying in January, February, and March for 2024 municipal elections, so that the commission can push registration links to those filers on Jan 1, because some of the qualification for office begins January 2nd. So we don't want to do anything that would cause a delay for people who want to run for office. Those invitations to register expire after a certain number of days. So the mass email to all the filers about their notification to file, we are currently planning to send out in April. If we send it out too soon, it gets buried, they forget about it, it expires, or they create a username and password and they check out the system, and then when it comes time to file in June, they've forgotten that they have registered at all, and they try to create additional username and password, and it becomes a problem. So we're trying to be very careful in the way that we roll it out. Filers who were already in the system this year filing a Form 6, they will not need to re-register. Non-incumbent candidates have a way to register in the system to complete the form and file it with the Supervisors of Elections Office or the Department of State. We're working on our staffing, communication, and training plans for the rollout. We are also working on updates to our website information in the coming month to include training videos and publications in relation to qualifying with electronic filing, because that seems to bring about a lot of questions from the filers who contacted us, as well as communication with those local filers who will be switching to the Form 6 in the coming years. We plan to work with the League of Cities, with DMS and People First as we communicate pertinent information about e-filing. We're also preparing emails to agency coordinators and supervisors of elections about the upcoming changes. We are also diligently working on our staffing plan for temporarily augmenting current staff for the onslaught of filers during filing season. We anticipate hiring some customer service professionals to assist us with answering phones and basic questions regarding e-filing and navigation. We'll likely use outside staffing for this purpose. We've noted that outside of disclosure season, on an average day, the commission receives usually somewhere between 100 to 125 calls. We unfortunately do not have data from our peak season in terms of incoming phone calls, but we can easily say that our calls are double to potentially triple during that time. We also have obtained data about filing season and how many disclosures are filed each day throughout the filing season. A surprise to no one is that a majority of those forms are filed in June, mostly filed weekdays, although you can see with e-filing some weekend filings now. But between 1,000 to 1,500 forms a day on average during the month of June are filed in our system, presumably many others working on them and not filing in those days. So we're moving forward with that With that information, with the expectation that we'll have almost 40,000 filers in the coming year. And any contracts for staffing through a staffing agency would likely exceed my expenditure authority. So you can expect to see any proposal there to come before you for your consideration. And with that, that completes my e-filing report, unless you have questions.
Thank you. Does anybody have questions?
I do, just one, thinking about some of the cases we've had today and in prior times, do we keep track of the notices, reminders, warning letters that we get? Frequently in the documents, did they just disappear into the ether? Do we get them back? It would be very helpful when I'm looking over a case to determine whether or not, how I'm going to be thinking through it, to know that, yes, in fact, they didn't get it because we got it back. I mean, there is return mail services, but we don't really see that often. Are we just to assume that they just disappeared somewhere?
I'm happy to answer that question. The way the system is currently working is that local filers file with the local supervisor of election. So the case you heard earlier today, that was a local filer.
Yeah.
Those notices are sent by the local supervisors of elections, and we work to obtain, in your records there, you will see from that case that there is information that they got back from the post office regarding the certified mail piece. We also send out certified mail to state filers. We do get signed receipts and information back from the post office, but probably a surprise to no one is that sometimes it's just somewhere out there. The return mail doesn't come back, and the signed sheet doesn't come back either. With electronic filing, all of those notices by law are required to go by email. So that's why filers have to keep an updated email in the system. A failure to keep an updated email or failure to check email pursuant to the law is not unusual circumstances. It won't constitute a waiver of the fine. So now we will move to email. Communications from our office are logged in our it used to be FDMS, but now EFDMS. There are communications when we email somebody, when somebody calls us, we enter those communications. When a notice goes out, those communications are entered in. So we do track those that go from our office. And so next year, all of the communications will be tracked.
It's tied to a person, so they serve as a county commissioner, they miss 3 filings, we've warned them, we find them, then they take a break for 5 years, and now they're gonna be a city councilman or something. We'll still know that when they miss their filings then? Is it like a contact management system that will be able to know that they are poor at filing?
Through the chair. Yes, if somebody were to leave office and then come back a few years later and run for another office, we still have them in our system from their previous position and their filing history. They have a personal identification number that the coordinators help us match up.
How long are those kept? Is there like 7 years like the IRS, forever? Like what's the?
Well, through the chair, we keep the forms themselves. The retention is 10 years.
Thank you.
Does anyone else have any questions? With that, is there a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
All right.